Very important in this judgment, we have a divided constitutional court, which I will tell you about shortly. The citation ZACC 9 is our Safley reference, 2024 ZACC 9. This is from the 22nd of May, 2024, and is obviously now the final word on the subject matter. That's bundle page 73, summary page 6. Now, importantly, we had a very divided constitutional court here. Tron J penned the majority judgment, concurring with Tron J's Collipin J, Matopo J, Rogers J, Cheeky J, and Van Sale AJ. The minority judgment was penned by Skippers AJ, but Zondo, Chief Justice, and Maya, Deputy Chief Justice, concurring. So we have essentially a 3-6 split in terms of this, but with the Chief Justice and the Deputy Chief Justice following the minority. Oh, thank you. I got some coffee. Yippee. Now I can go on. With the Chief Justice and the Deputy Chief Justice concurring with the minority judgment. So what happened in DHB? Now, this was a very interesting judgment, which I think is going to be quite relevant in a couple of matters. And it dealt with a prenuptial contract. And I say prenuptial contract because it is separate from the antenuptial contract. It dealt with the issue of maintenance and with pacta sunt servanda, which I will deal with shortly. So the case concerned the enforceability of a prenuptial agreement providing for maintenance on dissolution of the marriage. In addition to this prenup, the parties had an antenuptial contract which is distinguishable, wherein they excluded community of property and the accrual system. So first they had the antenuptial contract. Then they entered into this prenuptial agreement, which included provisions for donations and maintenance upon death or divorce. This matter then went through the regional court first. It had a huge, long drive through the court system, making sojourns from the regional court to the High Court, from the High Court to the SCA, and from the SCA to the Constitutional Court. So there's a long history of interesting and often contradictory findings. The regional court upheld the enforceability of the prenup. So it said, look, the antenuptial contract, great, out and out, but there is this prenup, so we are enforcing this prenup with the donations and the maintenance. High Court came along and reversed it, saying that the prenup contradicted the antenuptial contract and undermined the provisions of the Divorce Act, specifically Section 7.2. The Supreme Court of Appeal then reversed the High Court's decision and followed what the regional court said in terms of upholding the prenup and finding it to be valid. The Constitutional Court, having the final word, dismissed the appeal from the SCA, affirming that the prenup is enforceable and does not conflict with the antenuptial contract or the Divorce Act. So it is possible to have a further prenuptial contract aside from the antenuptial contract, which regulates the matrimonial property regime of the parties. Obviously, I'm assuming a very, very chuffed regional court magistrate in this instance, having been exonerated, as it were, by the Constitutional Court, basically finding that the judgment was sound. Now, a lot of instances of different factors considered in this matter. Number one is pacta sunt servanda, the principle that agreements must be kept, people must be held to their agreements. The Concord looked at freedom of contract. Parties can structure their agreements as they see fit within legal bounds. It looks at donation agreements. The court found that the donations in terms of the prenup did not alter the matrimonial regime stante matrimonio, and they can coexist in harmony with antenuptial contracts. And then further, it looked at the Divorce Act, Section 7 thereof, and that these agreements are not contrary to Section 7. The Constitutional Court found that the appeal is to be dismissed with costs. Section 7.2, i.e. spousal maintenance, in terms of the Divorce Act, is a separate issue capable of determination unfettered by the judgments. And I want to be very, very clear that the Constitutional Court, in its judgment, made it very, very direct and clear to the parties that the law, or the rights that they have in law. Sure, sorry, it's the cold in Johannesburg made me seize up for a second. The parties still have their remedies in terms of law, in terms of Section 7.2 and the antenuptial contract. The prenup is a separate issue that was dealt with. Now, the quote from this, our notable quote on the question that was before the regional court, the SCA held that having regard to the definition and purpose, including the primary objective of the two legal instruments, these instruments could coexist. This is because the ANC contract regulated the matrimonial regime, stante matrimonio, whereas the prenup had no bearing at all on the nature of the matrimonial regime and the respective estates of the parties. Their estates remained separate. Thus, the provisions of the ANC would remain intact and would be applicable upon the divorce, despite the respondent's entitlement to enforce the terms of the prenup. Now, this is very, very interesting. Also, consider the minority judgment of Schippers AJ, also quite persuasively written, and as I mentioned, the Chief Justice and Deputy Chief Justice both aligning themselves with the minority judgment. When you read this judgment, obviously the majority judgment is the binding one. However, the minority judgment may still also have some persuasive effect in terms of dealing with the subject matter in future. That was the judgment of DHB versus CSB, and that is Constitutional Court, and that is ZACC 9. Yo, that's interesting. Section 6 of the Maintenance Act provides any written or verbal agreement regarding maintenance is enforceable. So we'll be able to enforce the prenup in maintenance courts. Yeah, absolutely. I'm quite sure that that will be the case. Now, what is quite interesting will then be on the forum that the parties approach. If there is a divorce, we would probably see it in the Rule 58 or the Rule 43 courts, whilst there's a stante matrimonio kind of position that the parties are still married pending the divorce, and then finally at the divorce courts. But very interesting point. I think that you would certainly be able to rely on these types of agreements in the maintenance courts.